Okay, so when a company becomes insolvent, what are the liabilities on the directors, or are there any particular implications on the directors of the company?
That's a very interesting question because it's a very evolving set of circumstances that's been happening over the years. Now, if you look at it on the face value, a director is merely an employee of a limited company.
Yes.
And that limited bit in the company's name means limited liability, which means nobody can pursue the directors personally unless they've given a personal guarantee.
Yes. Okay.
So,
Has there been any circumstances otherwise?
like I said, it's a very evolving piece of legislation that's
Could you,
happening.
I mean, in your line of work, could you give examples where a director has been implicated and an example where a director hasn't been implicated?
Okay, so limited liability, director is an employee. The creditors cannot touch the director at this point.
Okay.
However, if they can prove the director has breached his fiduciary duties by way of either negligence or fraud, then the creditor has an option to pursue the director personally under a tort of negligence claim.
Okay.
And then that's where we're seeing a lot more changes, even to the extent where HMRC are now using something called a personal liability notice, a PLN, to issue against directors where they believe that the directors have suppressed sales or underdeclared taxes, because they've breached their duty by doing that, and
Okay.
therefore they're using Schedule 21 of the Finance Act to pursue
Okay.
directors personally. So that's an example I've seen, a live example I've seen going forward. But yes, I mean, I've also had seen letters, company directors, you are personally liable for the company's debt.
Okay.
Now, the first thing I said to the directors in those cases, when you entered into contract with this particular creditor, did you sign a personal guarantee? Can I have a look at the terms and conditions, any account opening forms? And if there's no mention of a personal guarantee, then the creditor does not have a right to pursue the director personally at all.
Okay. So it's all down to directors. If they've signed a personal guarantee or if they've given a personal guarantee, then they can be personally held responsible or liable, which means that the creditor can go after their personal assets. Is
That's
that
correct,
correct?
yes.
Okay.
That's
And if
correct.
they haven't signed a personal guarantee, then the buck stops with the limited company. The minute that that the limited company goes insolvent, that is the be all and end all of that matter.
Yeah, again, correct. That's right, yes.
Okay.